Welcome to the silent verdict.
With Clara Monroe and Elias Gray.
2 judges arrested by the federal government? I mean, what's going on there?
Yeah, that's not a headline you expect to read. Definitely caught my attention.
Right. It's pretty much unprecedented.
Yeah.
So that's why we're doing a deep dive today into these cases. We're looking at Wisconsin Judge Hannah Dugan and former New Mexico Judge Jose Joel Cano.
2 sitting or recently sitting state judges facing federal charges. It's quite something.
Exactly. And our mission, really, is to pull out the key facts. What are they actually accused of? We'll look at the government's own filings, media reports.
And try to make sense of the legal side without getting lost in, super dense legal jargon.
Yeah, and figure out what the bigger picture might be here. These are genuinely remarkable actions.
The rarity alone is striking. Federal arrests of state judges. It just doesn't happen. It immediately makes you think about, the whole federal versus state dynamic.
Okay, let's start with Wisconsin. Judge Hannah Dugan. The date was April 18th, 2025. The place, Milwaukee County Courthouse. Judge Dugan is on the bench. The defendant is Eduardo Flores Ruiz. He's undocumented, has a removal order against him, and he's also facing state battery charges.
Okay, so a complex situation already.
And then federal agents show up. We're talking ICE, CBP, FBI, DEA, quite the contingent.
Wow, multiple agencies. What were they there for?
Their plan was to arrest Flores Ruiz after his hearing. They knew he'd be there because his name was on the public court docket. They had an administrative immigration warrant.
Ah, okay. And that type of warrant is crucial here, isn't it? The difference between administrative and judicial.
Absolutely. Can you maybe unpack that quickly?
Sure. So an administrative warrant, like the one ICE had, is issued internally by an immigration official. It doesn't need a judge's signature or probable cause in the same way a criminal warrant does. It's generally okay for arrests in public spaces.
But not private spaces.
Generally, no. A judicial warrant signed by a judge based on probable cause, that's what's needed for entry into private areas, like someone's home, or potentially a judge's private chambers, or maybe even the courtroom itself, arguably.
Got it. So Judge Dugan finds out these agents are outside her courtroom. She calls the chief judge, then goes out and confronts the officers, asks them point blank, do you have a judicial warrant?
Okay, so she's zeroing in on that distinction immediately.
Seems like it. And the chief judge apparently told her, look, ICE can make arrests in the public hallways, but not inside courtrooms or, private judicial areas.
Standard procedure, sounds like. Protect the courtroom space.
But here's where it gets interesting. The allegation is that Judge Dugan then went back in, sped up Flores Ruiz's hearing, and then told him and his lawyer to leave through a back jury door.
A back door, not the main public exit.
Exactly. And what happened right after that?
Well, this is where the government's complaint comes in. They emphasize that this back door is usually just for jurors, court staff, not defendants. So using it was highly unusual.
Makes it look like she was helping him avoid the agents.
Yeah, that's certainly the implication. But, and this seems really important, that back jury door, it apparently led right out into the same public hallway where at least one of the federal agents was waiting.
Oh, so not exactly a secret escape tunnel.
Not at all. And Flores Ruiz was actually arrested just outside the courthouse building after trying to run for a very short time. The whole thing was over quickly.
Okay, so let's break down the charges filed against Judge Dugan on April 24th. There are 2 main ones. First, 18 U.S.C. 1505. That's obstructing or impeding a proceeding before a U.S. department or agency.
Right, and the key words in that statute are acting corruptly or by threats or force.
What's the deal with corruptly? Does it mean, bribery?
Not necessarily just bribery, but the Supreme Court has actually looked at this statute recently in relation to some January 6th cases, and they've interpreted corruptly quite narrowly. It often involves trying to get some kind of illicit benefit or acting with a wrongful purpose that goes beyond just, say, hindering something.
And the government's complaint here, does it allege threats, violence, anything like that?
No, it doesn't. There's no mention of threats or force. And as we said, he was led out into a public hallway. So the argument is whether her actions actually rose to the level of corruptly obstructing an agency proceeding under that stricter interpretation. What even is the agency proceeding here? Is it the execution of the warrant?
That's a really good question. Is trying to serve an administrative warrant considered a proceeding in the sense this law intended? It's debatable.
Okay, charge number 2, 18 U.S.C. 27-1. concealing someone to prevent their discovery and arrest.
Right, and for this one, the government generally has to prove 4 things. 1, there was a federal warrant. 2, the defendant knew about it. 3, they harbored or concealed the person. 4, they intended to prevent the arrest.
Okay, element 1, federal warrant. We know ICE had an administrative warrant. Does that count under this specific law?
That's a major legal question mark. The statute talks about a warrant or process issued under any law in the United States. Is an administrative immigration warrant legally the same as, say, a criminal arrest warrant issued by a judge for the purposes of this statute? It's unclear.
Seems like a point the defense would definitely raise. And what about harboring or concealing?
Well, yeah. He was led out into a public hallway where agents were present and arrested moments later outside the building. Does that really count as concealing him? It seems a stretch.
Especially compared to, hiding someone in your basement for weeks.
Exactly. And then there's intent. The government has to prove she intended to stop him from being arrested.
But she directed him towards a hallway where she knew agents were.
Right. And the total time from when his hearing started to when he was arrested was reportedly only about 22 minutes. And agents were apparently watching him for at least some of that time before he even went into the courtroom.
So her defense could argue her intent wasn't to help him escape permanently, but maybe. What? To maintain order in her court, protect the integrity of the proceedings happening right there.
That seems plausible. Judges have a lot of authority over their courtrooms. You could frame it as her managing her space, not necessarily committing a federal crime to help someone evade ICE. It comes down to mens rea curation, her mental state.
The government will point to the court deputy's statement, though. The deputy apparently said using that back door was unusual and that the hearing seemed rushed. That suggests intent, maybe?
True. That's evidence suggesting it wasn't just routine courtroom management. But there's something weird here, isn't there? A missing piece.
Yeah, the chief judge. Judge Dugan spoke to the chief judge. ICE spoke to the chief judge. But according to the reports we've seen, the federal investigators didn't interview the chief judge.
Which seems like a huge gap, right? You'd think that conversation would be critical.
You really would. It feels like a significant omission in the investigation, potentially.
Meanwhile, Judge Dugan isn't on the bench right now. The Wisconsin Supreme Court suspended her temporarily while these federal charges are pending.
Which is standard procedure in many places when a judge faces serious charges, but it definitely sidelines her professionally for now. It's not a finding of guilt, but it has immediate consequences.
So context is important here too. You have people like former prosecutor Andrew McCarthy commenting.
Right, and he was critical, interestingly, not necessarily of the judge, but of the federal agents' tactics. He pointed out Milwaukee is, broadly speaking, considered a sanctuary city, meaning local government limits cooperation with federal immigration enforcement.
Which doesn't mean federal law doesn't apply, but it affects how agencies operate. McCarthy seemed to think the feds should have coordinated better before entering a state courthouse like that.
It raises that whole issue of federalism, the balance between federal power and state functions, like running their own courts.
Right. And this isn't the first time a judge has faced accusations like this, although maybe not federal arrest. There was that case in Massachusetts, right? Judge Shelley Joseph.
Yes, that's a really relevant comparison. Judge Joseph was accused of helping an undocumented immigrant leave a state courthouse through a non-public exit. There were also allegations she told the clerk to turn off the courtroom recording device.
Okay, turning off the recorder sounds potentially more deliberate in terms of hiding something.
It could be seen that way. And in her case, the defendant's lawyer was actually given immunity to testify against the judge. That might suggest the government felt they had a stronger case for obstruction there.
And how long did it take to catch the person in that case?
That's another key difference. In the Massachusetts case, the individual wasn't apprehended for about 2 weeks. Here, with Flores Ruiz, it was minutes.
Big difference. And what happened to Judge Joseph's federal charges?
Ultimately, the federal charges were dropped. She did face state-level administrative discipline from the Massachusetts Commission on Judicial Conduct, but the federal criminal case went away.
So, a similar situation, maybe even stronger evidence of intent in Massachusetts, and the federal charges were eventually dropped. Makes you wonder about the approach here in Wisconsin.
It does. And you can't ignore the political climate. There's been rhetoric from some federal officials about activist judges, claims that courts are holding us back on immigration enforcement. Attorney General Pam Bondi made statements. President Trump mentioned courts hindering removals.
So these arrests don't happen in a vacuum. There's a backdrop of tension over immigration policy and the role of the courts.
Absolutely. And it raises that serious question, could this have a chilling effect? If judges start worrying about federal charges for how they manage their dockets or courtrooms when immigration issues are involved.
Does that impact judicial independence? Does it affect how willing they are to ensure everyone gets a fair hearing, regardless of immigration status?
Those are exactly the concerns being raised. Okay, should we shift gears to New Mexico?
Yeah, let's look at the case of former Judge Jose Joel Canano. This seems quite different on the surface.
It does. This didn't happen in a courthouse during a proceeding. This involved property owned by Canano and his wife, Nancy.
And it involved a man named Christian Ortega Lopez, a Venezuelan national living on their property. Authorities suspected him of being in a gang and illegally having firearms.
So law enforcement got judicial warrants, proper criminal warrants. This time searched another location, arrested Ortega Lopez, and found some guns.
But they realized something was missing: Ortega Lopez's cell phone.
Crucial evidence in many cases these days, right? Especially if they suspect gang activity, communication, photos.
Exactly. And when they questioned Judge Canano, well, he admitted something pretty startling.
Yeah, this is the core of it. He apparently confessed to destroying Ortega Lopez's phone with a hammer.
With a hammer? Wow. When did he do this?
About 5 weeks before the arrest, apparently. He told investigators he did it because he thought the phone had incriminating photos or videos on it.
So a direct admission of destroying potential evidence because he believed it was incriminating, that sounds legally problematic.
To say the least. And his wife, Nancy Cano, is also involved. She allegedly showed Ortega Lopez his phone on a video call while he was already detained.
Wait, after Canano supposedly destroyed it? Or was this maybe a different phone or before the destruction? The timing seems a bit confusing there in reports.
That detail might need clarification, but the allegation continues that she offered to delete his Facebook account, which also supposedly contained incriminating stuff.
Okay, so the charges against them are different from Judge Dugan's. They're both facing counts under 18 U.S.C. 1512, which is tampering with evidence. Jose Canano for the act, Nancy for conspiracy.
Right. And unlike the Dugan case, where intent and the nature of the act are fuzzy, here you have an alleged confession to physically destroying an item specifically because it was believed to contain evidence of potential crimes, like gang involvement.
Yeah, if that admission holds up, the government's case on the evidence tampering charge seems, on its face, much more straightforward than the obstruction and concealment charges against Judge Dugan.
It certainly appears that way. Destroying evidence you believe is linked to a crime is a serious offense, regardless of who you are.
And Judge Canano is no longer a judge. Right.
Correct. He resigned after the New Mexico Judicial Standards Commission started disciplinary proceedings against him related to this. That resignation itself might be seen as significant.
What was his explanation for having Ortega Lopez and others on his property?
He reportedly claimed they were asylum seekers, that they had hearings scheduled, and had come through official checkpoints.
Okay, but even if that's true, it doesn't really address this separate issue of allegedly destroying the phone to hide evidence, does it?
Not directly, no. The legal status of the individuals versus the alleged act of evidence tampering are distinct issues.
So how is the government framing these two arrests together? Because they happen around the same time.
Well, Deputy Attorney General Todd Blanche issued a statement connecting both arrests, linking them to concerns about sanctuary cities and public safety.
Even though, as we discussed, Judge Dugan's case didn't directly involve Milwaukee's sanctuary policies being violated, and the Canano case seems totally unrelated to sanctuary cities.
Exactly. Neither case seems to be a direct legal challenge to sanctuary policies themselves, but the DOJ is framing them within that broader context of immigration enforcement and local cooperation.
Does this fit with any recent policy directives?
It seems to align with a memo from Acting AG Emile Beauvais back in January 2025, which signaled an intent for more vigorous immigration enforcement, including prosecuting related crimes like harboring or transporting undocumented individuals.
And the Trump administration generally has focused on state and local officials they see as obstructing federal immigration efforts, often citing the Supremacy Clause.
Right. Plus, there was that executive order President Trump signed just days after the arrests in late April 2025, titled Protecting American Communities from Criminal Aliens. It reiterated the goal of pursuing legal action against jurisdictions perceived as hindering enforcement.
So it feels like these arrests, whatever their individual legal merits turn out to be, are being presented as part of a larger federal strategy on immigration.
That certainly seems to be the narrative being pushed, which brings us back to the overarching implications.
Yeah, what's the big picture here? The fact that two state-level judges were arrested by federal authorities is, as we said, Extraordinary.
It really is. And the immediate concern is that potential chilling effect on the judiciary we talked about. Could judges feel pressured or intimidated when dealing with cases involving immigrants? Could it affect their ability to manage their own courtrooms impartially?
It definitely raises questions about judicial independence and ensuring access to justice for everyone who walks into a courtroom.
And then there's the federalism question again. Is this federal overreach? Are federal authorities stepping too far into the domain of state courts and state judicial functions?
Or is it simply enforcing federal law, regardless of the defendant's position?
That's the tension, isn't it? And you have to ask, are these specific cases being used strategically to send a message, to advance broader policy goals around immigration and sanctuary cities, perhaps separate from the strict legal merits of each charge?
The way the cases are being reported seems to reflect that too, right?
Mhm.
Especially the Dugan case.
Absolutely. You see different media outlets focusing on different aspects, some emphasizing the judge, helping an illegal immigrant evade ICE, others focusing on judicial independence and potential federal overreach. The narratives definitely vary, often along predictable political lines.
So, wrapping this up, what's the core takeaway for you?
For me, it's that these cases, Dugan and Konano, despite their differences, force us to confront some really fundamental questions
About judicial independence.
about the proper role and limits of federal power within state systems, especially state courts.
And about whether the justice system can become entangled with political agendas.
Exactly. We don't know how these cases will end. Maybe the charges stick, maybe they don't. But the fact they were brought at all, the way they were brought, has significant implications for judges, for the legal system, for that whole balance of power, regardless of the verdicts.
Yeah, the impact is already being felt just by the charges being filed.
So maybe the final thought to leave people with is this. You have two very different sets of alleged actions here. Judge Dugan's actions in the courtroom, Judge Kanazo's alleged destruction of evidence beforehand. The legal standards for the charges are different too.
Right. Obstruction versus evidence tampering.
So given those differences, what does the government's decision to pursue both these cases so publicly and link them rhetorically suggest about their bigger strategy? What might be the long-term consequences for the relationship between the federal government and the judiciary, not just state judges, but maybe the whole judicial branch?